Hi, I'm Radhika, I'm from AdviceLine, and today we're talking about social media. We strongly recommend that employers have a social media policy in place. The policy should address blogging and any online posts that are made outside or during work hours that affect the business. The policy could also include possible steps an employer could take to investigate and start disciplinary proceedings, and also possible outcomes for an employee should they breach the terms of the policy. If an employer doesn't have a social media policy, they may be able to rely on the implied terms of an employment agreement. These would include things like loyalty, trust and confidence, fidelity. If these terms aren't in an employment agreement, it may be difficult to start a disciplinary process, so we strongly recommend that employers have some general clause in their employment agreement that addresses social media conduct. In the absence of a social media policy or implied terms in an employment agreement, an employer may be able to rely on their IT policy, which may include things like social media harassment or conduct towards an employee which is not approved by the employer, may lead to disciplinary action. If an employee has posted negative comments about a customer or a client and this has become a problem for the employer may start disciplinary proceedings. If the employee is dismissed, the employment authority has made its position very clear that reinstatement will be declined. They've also suggested that it's really important to educate employees about social media conduct and tell them about the possible consequences. An employer can investigate into issues relating to social media by relying on exchanges between employees through social media if the issue began in the workplace, but the conduct took place outside of the workplace. An employer can ask an employee to remove derogatory comments made online. They have to reach an agreement. If an agreement is not reached, the employer can start disciplinary proceedings. They can also apply to the Employment Relations Authority for an injunction. An employer can dismiss an employee for comments made on social media. However, there are several factors that need to be taken into consideration. Most of them include whether there were any attacks against the employer, whether the company was brought into disrepute, the seniority or visibility of the employee. The employee would also have to show remorse for the comments made online and show commitment to not breaching any of the terms of a social media policy or employment agreement. An employee can challenge an employer. There was a very recent case that went to the Human Rights Tribunal. The employer didn't really end up following the proper process and had to pay $168,000 to the employee. Social media is a growing concern for employers. We strongly recommend that you have a social media policy in place. If you don't have one, please call us at EMA Advice Line. We'd love to help you. 0800 300 EMA.